Hello and welcome everyone to Virtual Patent Gateway's PTAB Practitioner Series, hosted by Virtual Patent Gateway founder Ashley Chung. Virtual Patent Gateway, VPG, was founded in January 2020, right before the pandemic, and Ashley has a passion for supporting PTAB practitioners and is committed to developing a growth mindset within VPG. Today, we're happy to have Mitch Yang to share his experience and knowledge on PTAB Oral Hearing best practices. Mitch is a partner at Carmichael IP, and he is a registered patent attorney with experience litigating cases in many of the top federal courts for IP litigation. His experience also includes post-grant review proceedings before the USPTO, beginning with some of the earliest IPRs in 2013, as well as appeals before the United States Court of Appeals for the Federal Circuit. This webinar will be recorded for future use. We've applied for Virginia CLE 1 hour pending approval. Ashley will notify you once that is approved. You're welcome to stay on camera for today's session, and there will be a short Q&A at the end of the presentation. And with that, I'll hand things over to Mitch.
Thanks for the introduction. I'm excited for this hour because my practice includes both PTAB litigation, which is IPRs, PGRs, and the like, as well as district court litigation. I've argued before many of the major patent trial courts, such as the Eastern and Western Districts of Texas, the Northern District of California, and the Federal Circuit. And while the foundations of patent law are the same in all of these different proceedings, there are quite a few procedural differences between these different forums, and knowing them is a key part of being able to transition between these different proceedings and being successful. Today, we're going to cover the PTAB oral hearing, including the procedure for requesting and conducting one, differences between PTAB oral hearings and other types of oral hearings you may be familiar with, such as a district court Markman hearing or a Federal Circuit appellate oral argument, and changes the PTAB has implemented since the transition to remote oral hearing early last year. So the first thing to know about oral hearings is that it's guaranteed by statute and by the USPTO's regulation. 35 USC section 316A10 provides either party with the right to an oral hearing as part of an IPR proceeding and empowers the director to prescribe regulations for the hearing. And the PTO has done so in 37 CFR section 42.70. Either party may request an oral argument at a time set by the board. Now, even though oral hearings are a statutory right, they're still optional and they can be waived. It's rare, but what you do is, instead of filing a request for an oral hearing, you file a waiver of the oral hearing. If both parties file waivers, the board will decide the case on the papers and there will be no oral hearing. But if either party asks for an oral hearing, then you're getting an oral hearing. So one of the major considerations as you're approaching the end of the IPR is, do you even want an oral hearing? And my answer is usually yes. There are quite a few advantages to having an oral hearing, such as you make sure the judges understand and appreciate the technology of the patent and the prior art. You can clarify arguments made in the papers, especially if you didn't have the last word. And you get a sense of what the APJs are thinking about the technology and the important issues. Although in acceptance cases where the technology is fairly clear-cut, it's hard to, if not impossible, to get a perfect read on how the final written decision will pan out. To give an example, I've had cases where both parties waived the oral hearing and the judges did a great job of reading the papers and deciding the case on the merits. It's certainly doable. But I've also had cases where I think being able to explain the nuances of an argument and how the technology works, that decided the case. And the judges would have missed critical details and the case could have gone, well, actually definitely would have gone the other way had it not been for the oral hearing. And sometimes the judges' questions will telegraph what they're thinking about in terms of technology in a different way than what you want. And you can use your answer to clear up certain misconceptions. And because of that, an oral hearing is your right and you should definitely take advantage of it. Before we get into the procedural weeds, I want to share a couple of resources. The first is the hearing guide, in which the PTO has helpfully explained the basic procedure of a hearing and compiled some of the most frequently asked questions. And the other is the sample hearing order, which provides an example of how the board expects the hearing to be conducted. It's a good resource for the first hearing, but the board will always issue an order in an IPR a few days after the requests for an oral hearing are filed. So you should always refer to the oral hearing order in your specific IPR, rather than the sample order I've included here. Because certain panels do things differently, and there will always be differences between the sample order and the order in your IPR. We'll talk more about that as we go along. The next thing to keep in mind are deadlines. These are set out in the scheduling order, which is simultaneously issued with the institution decision. The relevant deadlines for an oral hearing are usually numbered due dates 4, 6, and 8. But keep in mind that some panels will use different numbers for their scheduling orders, so it's the actual deadlines that count, not the number of the due date. The first deadline is the deadline to request an oral argument. As I said, oral hearings are optional, and if you don't request one, the panel will not order one. The second deadline is the date for requesting a pre-hearing conference. The pre-hearing conference is sort of like a mini hearing for discussing issues that could arise during the oral hearing, such as motions to exclude, but it won't cover the substantive merits of the case. That's for the actual oral hearing. And we'll discuss pre-hearing conferences a little later too. The last deadline in the scheduling order is the date of the hearing itself. If any party requests an oral hearing, you'll get a hearing order a few days to a week after the request and about a month before the argument. All of these deadlines are in the scheduling order. Keep in mind, though, that there are a few additional deadlines in the oral hearing order itself that the panel issues after either party requests a hearing. I'll cover those deadlines a little later. In order to guarantee an oral hearing, you will need to file a request for oral argument, or you can file a waiver to waive the oral hearing if that is what you decide. The request is filed as a separate paper and it has a few formalities. First, the request should include the amount of time for oral argument. This is usually an hour, but it could also be 45 minutes or a little more. If you request more time than an hour, sometimes the board will not grant you the full amount of time that you desire, but typically if you request up to an hour, you will get an hour from the board. Additionally, you should provide a list of issues to be argued. Those are the issues that to be addressed in the oral argument. And finally, any requests for audio and visual equipment. When oral hearings were being held in person at the PTO usually came equipped with a projector, an overhead projector, as well as a screen for. But if you wanted other equipment like an Elmo, those should be in the request for the oral hearing. For those of you used to district court litigation, the demonstratives are one of the easiest ways to be tripped up at an oral hearing. The PTAB has very specific rules that have to be followed on demonstrative, and there could be very severe consequences for violating. So one of the most important things I can say in this presentation is I can't stress how important it is for the demonstratives to comply with the rules. As you know and may know, in district courts, absent a specific standing order, and those are fairly rare, or something similar, pretty much anything goes. And I've exchanged slides for a markment order, something like 15 minutes before the hearing outside the courtroom. Unfortunately, that's not going to fly with the PTAB. Instead, we have very strict formalities on the demonstratives that have to be followed. Demonstrative exhibits have to be served at least 7 business days before the oral argument with the opposing party. That's 7 business days, not 7 weekdays. So that is actually more than a week in advance. And the demonstratives have to be filed no later than the time of the oral argument. The board's oral hearing order in your specific case in the IPR will tell you exactly when to file the demonstratives with the board and how. Usually that is 3 business days before the oral argument, but that could be sooner or later. Each party serves on the other party demonstratives it intends to use during the hearing 7 business days prior. So refer to the oral hearing order for instructions on how to file the demonstratives with the board. Usually they're filed 3 business days before the hearing, but that's specified in the oral hearing order entered by the board after either party requests an oral hearing. Usually this involves either emailing the demonstratives to the email address trials@uspto.gov or by filing demonstratives on PTAB E2E. The specific way that demonstratives are provided to the board varies case to case. And I've had in the same panel in different IPRs issue different instructions. One time they asked me to serve it to them by email. One time they asked me to file it on PTAB E2E. And then the third time they went back to email. So always refer to your specific oral hearing order for exactly how to provide demonstratives to the panel. In addition to the arguments in the demonstratives also include the case number, the page number, a label saying demonstrative exhibit not evidence, or a similar marking indicating that the demonstratives are not evidence, and citations to the papers where each argument was previously made. Most of those sound trivial, but 2 of the most important ones here are the page number and the citations to the paper. Even back when we had in-person oral hearings, usually 1 or 2 of the APJs would still participate remotely. Now all 3 of them do. And the way they follow along to your presentation is by the slide numbers on the bottom of the slide. So it's important to have all of your slides numbered. But more importantly, the slide numbering should always be right. During the hearing, whenever you change slides, you should announce the slide number that you're on. I know from lots of personal experience that the judges do not like it when attorneys flip through the slides without noting the slide number first. And I can't stress this enough. The slide numbers from the slide that you're using has to match the slides provided to the judges. If you're practicing your slides and you decide to reorder the slides, that's fine, but make sure that you keep the same slide numbers. Don't rely on PowerPoint's automatic page numbering feature. Always make sure that the slide numbers at the bottom of the page of the slide deck you're using matches the slide numbers given to the judge. As an example, I was in a case where both parties were revising their presentations up to the very last minute before the hearing. The last thing I did right before the hearing was check that the numbering on the bottom of the slides matched the version that was submitted to the PTAB, and the numbers did match. The opposing counsel in that case did not do the same thing, and their numbers didn't match. So eventually the APJs couldn't follow along to the slides because the slide numbers were completely different. And they had to pause the hearing to express their frustration, and that was not a good look. So always make sure that your slide numbers match the slide numbers that were provided to the APJs. And during oral argument, refer to the slide numbers so the APJs can follow along. The other thing I can't stress enough is that each slide, and preferably each argument on each slide, should have a citation to the paper, such as the petition, the preliminary response, the patent owner response, the petitioner's reply, or the cert reply. The reason for this is that because the PTAB has a very strict new arguments rule, and violations of this rule can be draconian. This can be particularly surprising to a district court practitioner because when I was doing Markman hearings in Texas, it's sort of anything goes. If there's an argument in the reply you haven't addressed in your briefing, you can respond to it. You can respond to it during the Markman hearing. And that's not the case at all for a PTAB hearing. I remember when I first started, this would cause a lot of heartburn in my patent owner cases. Basically, you got one shot at making your argument, the patent owner response. And then whatever the petitioner said in the reply, you couldn't respond to it at the oral hearing if the argument wasn't already made in the patent owner response, because it would be unsupported by what you've said in the patent owner response, unless they introduced the reply expert declaration, and then you could take observations, but that was it. Fortunately, the PTAB has changed the rules and added a cert reply, but at the same time, you have to always remember that if you don't have the last word, you need to anticipate what opposing counsel's response will be and build that into your papers. Because if the argument isn't in your papers, the PTAB is going to call it a new argument and disregard it. And this has been upheld by the PTAB in numerous decisions and even by the Federal Circuit. That the demonstratives provided in an oral hearing are only permitted to support the oral hearing and not used to advance new arguments or introduce new evidence. So it's always important to remember that slides containing new arguments will be disregarded. One of the most devastating responses opposing counsel can make is that's a new argument because the PTAB will disregard it. In fact, I'd say at least in 25% of my cases, the APJ have asked me, where in your papers did you make that argument? And I had to point out specifically which paper that was and on which page that I made the argument. And sometimes I'd even have to read out specific sentences to make sure that the judges knew that the argument was already made. The alternative is if you didn't make that argument, the judges will disregard that argument. And even if it's a winning argument, if you didn't make it, that could lose the case. So as a result, it's always good to have citations ready to go for all of your primary arguments. They should be located on the slides and easy to access so that you can always direct the APJs to exactly where the argument was made in the papers to ensure that it is not a new argument. The alternative, unfortunately, is sometimes if it's a very esoteric question, you would have to go back and read your papers to locate where the argument was made, and that takes up valuable time. But that's still important because if it's a new argument, it's going to be disregarded. One of the things that we saw a lot was the CBS Interactive case, in which the PTAB said if a significant number of slides was non-compliant, the board could exercise its discretion and not allow presentation of any slides at all. For a lot of people, you rely on your slides in order to carry your presentation, and not allowing slides at all could be devastating to your case. So it's very important to include these citations on the slides themselves in order to ensure that every argument is not a new argument. Because if I believe from what I've heard that the PTAB is more lenient about this now, but it's always important to make sure that you don't have a new argument in any of your slides. So always cite the papers where the argument was made to ensure that the argument is supported and it won't be disregarded or removed by the PTAB. So what do you do when opposing counsel includes new arguments or other objectionable material? Well, the first thing you have to do is 7 days before the oral hearing, 7 business days before the oral hearing, business, not calendar, exchange the demonstratives with the other side. And after that, you have a few days to review the demonstratives to ensure that all the material included in the demonstratives are non-objectionable and permissible. What you do that usually when I exchange demonstratives, I always include citations to every single argument and try to reproduce the arguments as they're made exactly in the paper. Sometimes you have to change a few words, but as long as the argument is made, that's fine. But I've seen other counsel to be completely safe. They've taken screenshots of their papers and just shown that verbatim. Typically, the PTAB will not see that as objectionable material, and they will always allow that. If you deviate from that, you run the risk of the opposing counsel objecting to it, and then citing the CBS Interactive case to try to throw out your slides. When you do see any objectionable material, what you do is you identify the objectionable material and provide that. Usually when I do it is in the form of a chart to the other side to meet and confer before the deadline to submit demonstratives by the board. It's important to note that if the parties don't object to any of the slides, then the board will permit the slides to go in. So if you do see objectionable material, it's very important to object to them. You object to them on the ground of new arguments or evidence. And then if the board sustains those objections, then those slides will not be permitted to be used during the oral hearing. Normally, to avoid these objections with new evidence, those certain slides can be removed or reworded in order to remove the new materials. But if the materials can't be resolved, the demonstratives and the objections should be filed with the board, and then the board will take up those objections during the pre-hearing conference and potentially rule on them. Each objection should identify with particularity which portions of the demonstratives are subject to the objection. So if you have a slide with new material on it, you identify the slide number and the portion of the slide that has the new material or arguments on it. You should include a copy of the objected to portions and include a one-sentence statement for the reason for the objection. Unfortunately, the board doesn't permit argument or explanation in your objections that's filed with the board, but you can explain that to the board during the pre-hearing conference. As I said, the easiest way to resolve these objections is during a meet and confer, and where you include additional citations to portions of the papers where you made that argument, or you remove any objectionable new materials. The objections will be considered at the pre-hearing conference, and any objection that isn't made is waived. So if there is new arguments and you didn't catch it in time, unfortunately, that new argument will be permitted at the board. So it's very important to check to make sure that all the citations cite to papers in which the arguments made in the papers support the arguments in the slides. The pre-hearing conference is where both parties discuss issues that may be raised during the oral argument, except for the substantive matters that are decided at the oral argument. Either party may request a pre-hearing conference in advance of the hearing, and sometimes the board will sua sponte set one for you, although in my experience that has been rare. If neither party asks for a conference, then unless the board sua sponte does it, no pre-conference hearing will be held. The main purpose of the pre-conference hearing is for the parties to preview issues to be discussed at the hearing and seek the board's guidance about particular issues that the panel would like to be addressed by the parties. Sometimes the board will flat out tell you what arguments they're interested in and what arguments they are not. In one of my cases, we had an issue with a swear behind from the inventor, and the issue boiled down to whether the patent specification supported the claims. And the board flat out told me that they could read the specification for themselves, they could look at the claims and determine that issue on their own, and they weren't really interested in looking at that issue or hearing about it during the conference, or hearing about it during the hearing. So in that case, when the board has already told you that, sometimes if you disagree, you have to make the argument anyway, but if you have other good arguments to make, then because of the limited amount of time, it's important to focus on the arguments that the board want to hear rather than the arguments that the board has already indicated may not be very persuasive. So like I said, if your IPR includes a couple of long shot arguments or legal issues that may not decide the merits of the case, the conference, sometimes the board will tell you in the conference that they're not particularly interested in a particular issue. And then you would know that either you think that's an important issue and you push it anyway, or maybe it's not a particular issue and it's better to save your time for it and a case determinative issue. So prior to making that request, the parties should meet and confer and send a joint request by email to trials@uspto.gov and with a set of issues for discussion and proposed times for the conference. The other thing that's usually discussed at these conferences, pre-hearing conferences, are, as I said, issues dealing with the demonstratives or other motions to exclude. If you have certain new materials in your demonstratives, the board could very well rule on that issue at the pre-hearing conference. So be prepared to explain to the board either why the opposing counsel's demonstratives include new materials or why your demonstratives do not include new materials. One of the things that's changed in the past year or so is the switch from in-person hearings to remote oral hearings. I wouldn't call it the fortune, but I've had the experience to do a remote hearing before 2020, and unfortunately, it's certainly not as effective as doing it in person, especially if you need to make full use of your demonstratives, such as if you have to explain your claim with a flowchart and you need to point to the elements to explain of the algorithm to explain how the algorithm proceeds step by step. The most effective substitute I found is to make full use of the camera. Sometimes you print out the flowchart, hold it over the camera, and then use your fingers to direct the board exactly each of the individual steps. As for etiquette, the judges will be sitting at desks, and from what I've seen, most practitioners do so as well, although I've seen some others stand at a podium in front of a camera. But as far as I can tell, the judges have no preference whether practitioners are sitting at their desks or presenting in front of a podium. It's probably best, though, not to have your Zoom filter for cats on. One other important thing to pay attention to is that sometimes the judges will experience connection issues. They'll disconnect, their screens will freeze, and sometimes the judges will have lags and delays between the responses. If the judges disconnect or if their screens freeze, you should point that out and pause oral argument until that's fixed. The judges do understand that technology sometimes doesn't work correctly, and they will grant you extra time to finish your argument if that happens. In order to set up a remote oral hearing, after you filed the request for an oral hearing, and after the judges have issued the oral hearing order, the order will usually include the contact information for the PTAB's technical support to set up an oral hearing. For IPRs and other post-grant proceedings, that email is ptabhearings@uspto.gov, or alternatively call 571-272-9797. And in recent PTAB oral hearing orders, the PTAB has included the following language to directing practitioners on how to contact the board in order to set up their oral hearing. Usually the PTAB order each party to contact that PTAB hearings email URL at least 5 business days, and that's, again, business days, not calendar days, prior to the hearing to receive video setup information. In my experience, though, the PTAB has been very good about contacting practitioners ahead of that in order to set up a date to schedule and test your equipment for the oral hearing. Usually that happens at least 2 weeks beforehand. And in those emails, the PTAB will state that doing so beforehand satisfies requirements in the oral hearing order in order to contact the board. So most of the time, the PTAB has been very good about doing it beforehand and contacting you first to set up a time to test. What the PTAB usually does is send you a link and a dial-in information in an email and that link works for both the test date and for the actual hearing. The phone number that's provided in the email can also be shared with clients because oral hearings are technically publicly available, and clients can use the dial-in number provided in that email to dial in. In my experience, the board doesn't send any additional emails beyond the email for testing the connection. So there's not going to be a follow-up email or anything. I'm directing you on how to connect with the PTAB during the hearing. So it's important to just circulate that initial email for the test, and then have clients and anyone else who wants to join the hearing dial in at the time of the hearing. One thing it's important to note, though, is that only attorneys who will be arguing at the oral hearing should use the link provided by the PTAB. Anyone else who wants to participate should use the telephonic dial-in information instead. I've had a few cases where extra people use the video link and the board asked them to drop off and dial in. So to recap on this aspect, clients and the general public can listen in on oral hearing. Although with the way that oral hearings are scheduled by sending Zoom-like links and telephonic connections, I don't see how general public is going to dial in without that information. And the PTAB will reach out before the 5 business days stated in the order, with providing a link to test the video connection. That link is the same link that is to be used on the date of the oral hearing. And that satisfies the requirement the board has in the oral hearing order to contact the board to set up a time to test the hearing equipment. And that same video connection, it's used in both the test and the actual hearing. But I've never experienced this, but if the PTAB doesn't reach out, do contact PTAB hearings at USPTO.gov as specified in the oral hearing order in order to set that up. So the format of an oral hearing is pretty similar. I would say almost exactly identical to a Federal Circuit appellate oral hearing if you had an hour instead of 15 minutes. The petitioner will argue first, and the petitioner will usually reserve some amount of time for rebuttal. So if for a 1-hour oral hearing, usually that's 45 minutes of opening argument and 15 minutes of rebuttal. There is a rule that the board will not permit you to reserve more time for rebuttal than your opening statement. And then after the petitioner goes, then the patent owner will respond after the petitioner. As as like the petitioner, the patent owner can also reserve a brief SIR rebuttal in order to respond to the petitioner's argument. If anyone has experienced Markman hearings, the rest of this might seem familiar. Like a Markman hearing, you should expect technical questions from the PTAB judges. And one of the most important pieces of advice I can give is to know the technology of the patent, know the patent inside and out, because the PTAB is expected, and they will ask technical questions about the invention, and they will ask technical questions about the prior art. The most important thing in winning a IPR and in succeeding in an oral hearing is knowing this information so you can respond correctly to the PTAB judges and to their question. On the other hand, even though the PTAB is interested in the merits of the case, and even though they're interested in how the technology works, how the patent works, how they're different or how they're anticipated or obvious, sometimes the PTAB will also ask legal questions, even though that may not be the focus of the case. For example, in some of my cases, one of the judges would ask whether the claims are supported under 112, whether there's sufficient specification support for that. Even though technically in an IPR, that is not one of the grounds of rejection, so the judges that's technically not relevant. But still, the judges sometimes will ask those kinds of questions. It's important to remember, though, that an IPR is technically part of the prosecution history. So you always have to come up with a good argument or answer to defend those kinds of questions. So those kinds of things don't trip you up when you go back to district court. The most important thing when using slides, though, is always to identify the slide number and make sure that they're correct. Because the PTAB judges, they follow along to your presentation based on the slide numbers. If you identify the slide numbers ahead of time, because they're all remote, they'll be looking at those slides and they'll be following along. If you just speak without identifying the slide numbers, a lot of the time the judges will interrupt you and ask you what those numbers are so that they can follow along. Always know which of your key slides explains the technology. In a lot of my cases, I've noticed that the judges, sometimes they'll ask very probing questions about exactly how the patent works. So you always want some key slides describing that you can always keep referring back to in order to explain the technology. For example, in one of my cases, it was dealt with a very specific algorithm. So I had a detailed flow chart pointing out exactly how the steps of the algorithm worked. And then I explained why the prior art didn't perform those particular steps in the claimed order. And then sometimes the judges would pose hypotheticals. What if the prior art had this? Does the prior teach that based on this description? And you can always flip back to the flow chart describing how the technology works and compare that to the prior art to show that technology doesn't do what the prior art says. So it's always useful to have a few key slides explaining the technology that you can go back to know why the technology and the prior art are different. Or in the case of a petitioner, why the prior art and the technology are the same. The other most important thing is always be prepared to refer back to the papers to support an argument. Because as I stated previously, one of the most devastating arguments an opposing counsel can make is that's a new argument. Because if it's a new argument, then the board will disregard it. And even if it's a winner, if it's disregarded, then it's no longer a winning argument. If the arguments on the slides already come with citations to the record, then you should always point the board to those citations. And always make sure that the citations to the record are to the most clear argument that supports the argument you're making during the oral hearing. Sometimes the arguments in the papers are not as strong as the arguments in the oral hearing. Maybe you've had an opportunity to refine them since. And then in those cases, you always want to find the best arguments in the papers to support what you're saying in the slides. Otherwise, the board could deem it to be a new argument and exclude it or not consider it. As I stated earlier, most oral hearings are 1 hour in length. You will have 1 hour combined to do both your opening argument and a rebuttal or a SIR rebuttal. The judges will note the time with their clock as the official timekeeper. Back when oral hearings were in person, there would be a clock in the hearing room that the judges will use, and that would be the official time. So it would be very easy for anyone arguing that oral hearing to look up at the clock and know how much time is left. Unfortunately, once oral hearings have transitioned to remote oral hearings, one of the judges usually keeps time on a watch or the cell phone. So in those cases, it's very important, if you want to manage time correctly, to also keep track of that on your own watch or cell phone. Sometimes I've had another person come in and do that for me, so then I can concentrate on the argument. And most of the time, the judges will ask you if you want to be reminded of how much time is left, like maybe 5 or 10 minutes before the end of your opening or rebuttal argument, and that would be a useful clue. But if you wanted to have more information about exactly how much time you have left, it's always good to come prepared with your own watch or cell phone. Assuming no one has any questions, I can talk a little bit more about specific mechanics of. Oh, I see we do have a question.
Yeah, let me get Jim.
Can you hear me?
Yes.
Okay, Mitch, I know you've had some wins against some giant law firms with giant legal teams that sent a lot of people to the oral argument, and wonder if you have any comments about that. And then secondly, if you could comment on, who on a team would be the best person usually to do the oral argument, and can you share the podium and so forth?
Sure. I've been fortunate in that I've worked at a lot of small firms where they want the person who knows the material the best. That is the person who writes the patent owner responses, the person who writes the preliminary responses, the person who writes the replies and surreplies, that person to do the oral argument. I think in most situations, assuming that person knows how oral arguments work and the materials behind it, that person is usually the best suited for an oral argument, because a lot of the times the PTAB judges will ask a lot of detailed technical questions on how the technology works, what the patent discloses, what the prior art teaches. And the person who developed those arguments, I think, is in the best position to respond to those arguments, because they will know exactly what arguments the PTAB is looking at and what counter arguments there exist in the prior art or in the patent to answer those questions correctly. One of the other things I've been fortunate about is I work on both the district court litigation and the PTAB litigation side. So typically I'm familiar with both the infringement theory and the invalidity theory. And I feel like that is one of the most helpful aspects of PTAB litigation that a lot of other practitioners don't realize, because sometimes you have a very good argument for infringement and that completely destroys your validity case. Or sometimes you have a very good validity hook and that completely destroys your infringement case. Most of the time, the PTAB litigation team and the district court litigation team will meet beforehand and hash all of that out so that certain arguments are landmines that you shouldn't step on or make. But in the heat of a PTAB oral argument, sometimes the judges will ask certain questions and something will come up. And it's always important to remember that a PTAB oral argument is part of the prosecution history record. So any statements you make there, that will impact the district court litigation case. So someone who understands both the infringement and validity side, I think is most suited for answering those types, being there and at least having someone who knows that confirm that the answers are are acceptable. And I've had cases where two attorneys are there. One attorney does the oral argument and one attorney stands back and listens to it. And sometimes there'd be something that the arguing attorney says that could be problematic, and that has to be cleared up. So they'd pass notes between each other and clear those arguments up. As far as the number of attorneys go, in my experience, as long as there's an attorney who's experienced in PTAB oral argument and there's an attorney who knows the technical side of the case, that is sufficient. I've had cases where counsel for both parties invited their clients to attend and their clients were there, and the PTAB judges acknowledged the clients but didn't do much more than that. Obviously it's reassuring for the clients to be there and to see the argument, but I don't think that impacts the PTAB judge's decision. And I also don't think there's much impact of the decision based on the number of attorneys that are there. What they're looking for is the technical merits of the case, the technical arguments. That's the thing that they're focused on, not on how many attorneys contributed to the brief.
Can you describe your experience doing oral arguments against giant teams of lawyers from giant law firms?
Well, I've done both oral arguments against giant law firms and against smaller law firms, and they're very similar in that the lawyers are highly competent. They know what they're talking about, and for the most part, they have great answers to the PTAB. I've noticed, though, in some cases, for larger law firms, the partner arguing the merits of the case, sometimes they read the briefing, they read the patents, and they read the prior art, but sometimes they don't really think about issues that aren't at the foreground of the merits of the case. Sometimes they're background issues, and sometimes the judges will ask questions directed to those issues, and that could be challenging to answer without the attorney who actually developed those arguments there. For my arguments against, I suppose, smaller firms where one attorney does all the briefing and does the arguments, that's less of a problem because that attorney should know the answer, assuming he spent enough time on it. In my experience, those kinds of arguments have less issues of the attorney being stumped by a particular question by the judges.
Have you seen your opposing attorneys at oral argument do anything that you thought was especially good or especially bad?
I'm always impressed when I'm arguing against the other side how much they know about the technology, because I pride myself on reading the patents, reading the prior art, figuring out everything, and I'm always impressed how prepared the other side is. Even the most senior attorneys who I argue against, they know the technology very well, and it's always a challenge coming up with arguments to defeat.
Thank you.
I want to thank Mitch for taking the time to do this PTAB oral hearing best practices for us today, and for Jim to providing or actually having Mitch to speak with us. We have a lot of practitioners on this forum. I wonder if anyone else has questions. And if yes, feel free.
Hey, this is Kevin McNish. Really enjoying the presentation. I had a question for you about the pre-hearing conference. So I have done them where I basically just go to the board and say, hey, what are you interested in? Just to try to figure out how to use my time efficiently at the oral hearing. What are your sort of best practice tips for, requesting pre-hearing conference, and then also, what issues you want to address at that conference, or even if that's just, asking the board what they want to hear about?
Well, I tend to put my arguments into two buckets. There are the technical arguments where this is what the technology, this is the technology of the patents, this is what the patent says, this is what the prior art says. Those kinds of things you have an expert opine on it, but besides that, there's not really much of a dispute between the attorneys over what the technology is or what the patents say. And then I have more of a bucket full of legal issues like claim construction, and then priority date and other things where there's less expert opinion on it and more just legal issues on how to resolve that. For the first bucket, I feel like the board is fairly interested in that, but I think the attorney has a better idea of exactly what kind of technical argument is meritorious and I don't think the board really provides guidance on that. But for legal-ish questions like claim construction, priority date, those are great questions to ask the board at a pre-hearing conference because they are in the best position to know what they're interested in. With respect to asking the board or anticipating what they're going to say, most of the time, I personally do not request pre-hearing conferences that much because and most of my cases come down to technical issues and not to legal issues. Most of my cases are, yes, this is what the algorithm of this patent is, and this is not what the algorithm performed by the prior art, or this is the algorithm performed by the prior art. That is something that the board that is something that if the board gets, then you win, and if the board disagrees, then you lose. There's not much more you can do about that. So the focus there is on making sure that the board understands exactly why your technical argument is meritorious and convincing them and then having them find for you on those. But for more legal arguments that could go either way, those are the arguments that I feel like is the best to seek guidance from the board for because because the board, when they give you guidance on those, they're telling you what arguments they're interested in, what hose might be in the briefing, what issues that need to be addressed. And those are the ones, if the board actually gave me guidance on one of those legal questions, I would definitely use that guidance to present that issue in the oral hearing.
Hi, Mitch. This is Steve Schreiner. Nice job on the presentation. I found it really informative. I've just got a question of form, and maybe you covered this and it slipped by me, but I still want to know. And that's, do you think it's better to refer to the parties as, petitioner and patent owner, or use the actual parties' names during oral argument?
So I do a lot of district court litigation, and all the other district court litigators keep telling me that that judges and district courts prefer that you refer to the parties as using their names instead of plaintiff or defendant. And that's what I've carried over into my PTAB work, and no one has told me different.
Got you. Thank you.
It also seems to me that if you do it that way, it's easier for the judges to remember which party is doing what.
Yeah, true. Thanks.
Hi, Mitch. My question is if you have any perspectives on the best practices for pre-drafted rebuttal or surrebuttal slides you use in case the other side argues something but aren't part of your main argument. Do you tend to include them? Do you have any tips on how you present them, for example? Do you include them in your main argument? Or do you kind of keep them at the end and just stop if you feel like you didn't need to get to them?
That's a great question. But the most important thing to know there is that all those rebuttal slides have to be addressed by your papers. If they're not in your papers, the board won't accept them because they're new arguments. And that's particularly critical if you're not getting the last word in on a particular issue. For example, if you are the petitioner and you've already made your arguments and the patent owner gets a sur reply, they said something there that you don't get a response to. So you have to begin when drafting your papers in order to, as I said before, anticipate exactly what arguments your opponent is going to make in the subsequent paper and include those arguments, or at least enough to support the arguments that you will make, so it's not a new argument. Include those arguments in your paper so that you can cite to them later in your presentation. The way I tend to do it, though, is if for tangential issues that are not directly implicated by the primary technical argument, I tend to leave those at the back of the slides. That's why I referred earlier to always have a slide that explains the technology. And whenever the judges have a question about the technology, refer to those slides. I keep the rebuttal slides to particular arguments at the back of my slide deck and refer to them as needed based on the presentation that the other side has made. Normally, I do a lot of patent owner side work, so it seems to me like it's easier as a patent owner to respond to arguments that the petitioner has made, because the petitioner, as I said before, goes first, then they make a reply, and then you get a sur rebuttal. So you have an opportunity in both the patent owner's statement and in the sur rebuttal in order to present those particular slides. For petitioners, though, again, it's a matter of anticipating what the patent owner is going to say. And in a lot of situations, I've seen petitioners get burned because they had a great argument. The issue was either they didn't include it in their petitioner's reply because they didn't think the patent owner was going there, and then they couldn't include it in their presentation because it became a new argument. Or during the presentation, they didn't get to it because they didn't think patent owner was going there. For petitioners, I think it's very important to anticipate what patent owner is saying. And I know this is something that's not really a science, more of an art in order to anticipate what your opponent is going to do. But for petitioners, it's particularly crucial to anticipate what is going to happen, and then to use and to cover those before the other side has a chance to, and then you wouldn't be able to respond. As I said before, this actually used to be an issue for patent owners before the sur reply because petitioners got the last word. When I was doing patent owner or at that stage, it was incumbent on the patent owner to anticipate what the petitioner was going to do, what they were going towards, and then include those arguments in the patent owner response, include those arguments as slides, and then present them to the board ahead of time before the petitioner's reply in order to address those arguments head on before the petitioners had a chance to, and then you wouldn't be able to respond. So it all depends on who gets the last word at the oral hearing. If you do not get the last word in, then you have to make sure that the arguments you want to preserve are presented. If you do get the last word in, then it's perfectly fine to save them.
Anyone else have questions? Can everyone unmute themselves or have the capability of doing that?
They have the power.
They do have the power. So, someone said something?
Mitch, I'd be interested to hear more about the uh, possible decision to not request an oral argument. When would that be a good idea?
In my opinion, that's almost never a good idea. And the reason for that is because even if you do the best job in your paper, sometimes reading an argument in the papers and just having it explained to you is two completely different things. So if you have a chance to clarify what you said in your papers, to make sure that the APJs understand what you said, always take that chance. The few times that the parties waived oral argument, it was mostly logistical reasons. As one of the rules of PTAB oral hearing is that the lead attorney has to be present at the oral hearing, and sometimes for whatever reason the lead attorney may have like a trial or a deposition at the same time and they can't make it. With that in mind, sometimes the parties will agree to waive the oral hearing. But besides that, I rarely think it's a good idea not to have it.
Okay, and now that we're still all on Zoom for oral arguments, is it okay just to wear a t-shirt for your oral argument?
I don't recommend it.
Not if you do dress up as a cat.
Yeah, don't use cat filters. Don't wear t-shirts. It's still a formal legal proceeding. You are on video with the APJs, and I do not recommend looking informal at all.
Okay, thank you.
Jim, this is Jessica Marks. I just thought I would, because it's so unusual, we have waived oral arguments before when the patent owner didn't file a patent owner response. Then we don't want to open it up for, them to say anything. There is no reason. We would just rest it on our paper. Sometimes we decide to do that, but of course you can imagine that's incredibly rare.
Yes, because if you don't file a patent owner response, you're essentially conceding the institution.
Unless you specifically say you're not conceding and you still want to go forward and you refuse to disclaim your patent, then yeah, we don't see how it would turn out any other way. But that is the one unusual chance that came up.
That's true. If you already have the last word and you don't want to give your opponent another last word, then yes.
Mitch, do you actually anticipate there's going to be any in-person oral hearing anytime soon?
To be honest, every single oral hearing I've had, at least one, if not two of the APJs were remote. And I feel like the patent office at this stage has become so used to doing things remotely. Even before, when I was an examiner, lots of the examining court were working remotely. They weren't in the office. That I think now that we have the technology set up to do it oral hearings remotely, I don't think it's likely that we'll go back to in-person hearings, even though for attorneys, I think that in-person hearings provide a lot of benefits that you can't get from a remote.
So one of the reasons why I asked that is that when we had in-person hearings, I used to work for law firms. So one of the things that we usually have to do is like get all your printout of the demonstrative, make sure that you QC them and make sure everything like looks like pristine and get them to the court reporter and the ALJ that actually were there. Usually it's in hearing room 8. And I guess, with remote hearing, that takes care of that type of QC. You just have to make sure your demonstratives are actually, get all your site checking or all your QC done. So I guess that's one of the reasons why I wanted to ask, do you anticipate any of those in-person hearing coming back? Because, PTAB does have a lot of several physical locations. So if it's all remote hearings, how would that actually work? I mean,
the interesting thing is I have had oral hearings in both the Alexandria and the San Jose office. And even though the PTAB judges were assigned to the San Jose office, there was still only one judge there when we were there. Mm-hmm. So that's why I'm skeptical that we will go back. The other thing I will say, though, is that even though we're remote now, it's still a good idea to have a hard copy of your doc in front of you. As I said before, sometimes you have demonstratives, and it's very important to explain exactly how things work and to point to certain figures to highlight those figures and show exactly how the algorithm is done. And it's easier if you have a hard copy of the demonstratives, you have a piece of paper you can show in front of the camera, rather than trying to explain it conceptually and hope that the judges get it. And the other thing I've noticed is that if you have a paper copy, sometimes if you're looking for citations, sometimes depending on who's reading it, sometimes having a paper copy could help you find certain things that you might, especially if you have like stickies and notepad. mark everything with notation. And sometimes that's easier to flip through.
Thank you.
Thank you.
Mitch, this is Steve. On the issue of a party considering waiving its right to an oral argument, do you think one one reason why you might try to persuade that party not to waive that right is that have you had the experience that an APJ has already formulated his or her reasoning, let's say kind of the lead APJ on the case, has formulated his or her reasoning for coming out one way or another, and if you're going to be on the bad end of that result, you have an opportunity to answer the APJ's question directed to some particular issue. Like sometimes it seems like the APJs will preview where they're going with the decision, and you have that's your kind of your last opportunity to explain why they're wrong or on the facts or on the law.
That has happened to me where I thought the APJs were going to go one way and we managed to turn it around at the oral hearing by explaining exactly how the algorithms were. As far as having an oral hearing itself, in order to prevent that, keep in mind that as long as one party requests an oral hearing, the PTAB has to grant it. It's not based on consent between both parties. So there's really a lot of incentive for at least one party to request an oral hearing. And as long as one party has requested an oral hearing, then be prepared to have it. The only time an oral hearing is not done is if both parties waive the oral hearing entirely. And there's just not a lot of incentive for both parties not to have an oral hearing.
Thank you.
Well, we're right on time. And if there's no other questions, I guess we could go on to our afternoon. Thank you so much, Mitch. And thank you so much, Jim. And everyone, have a great afternoon.
Good afternoon.